Good afternoon, everybody. Welcome to B-Side Las Vegas, to the Proving Ground, and this talk, Cover Your Ass, by Suchi. A few announcements before we begin. We would like to thank our sponsors, especially our Inner Circle sponsor, Critical Stack and Belly Mail, and our stellar sponsors, Amazon, BlackBerry, and Robinhood. It is their support, along with our sponsor, donors, and volunteers, that make this event possible. These talks are being streamed live, and as a courtesy to our speakers and audience, we ask that you check to make sure your cell phones are set to silent. If you have a question, or use the audience microphone so YouTube can hear you. Please raise your hand and I will bring it over. Thank you.
All right, thanks so much. I appreciate it. All right, guys, if you can't tell, I'm really excited to talk to you guys today. And I'll hopefully be able to advance. Yes. So my name is Suchi. I'm a data privacy and cybersecurity attorney. You can find me on Twitter. I've been practicing for about 5.5 years now in a field that's really not super well developed in the legal world. And I really like to talk to people like you about how to keep yourselves safe from clients who are trying to screw you over. And after kind of dispensing that advice on the side to some friends of mine, I decided that it was worth it to make the time to actually do a full-on presentation. And hopefully you guys will be able to use some of the resources at the end of the slide to help yourselves if you're an independent security consultant, or send these forward, or download the slide deck, or burn it in a dumpster. I don't really care, but hopefully you get something out of it. So first, before I start with the actual deep, important things, I am not your lawyer. This is not legal advice. We are not in an attorney-client relationship. This is all informational only. I drink and I know things because I am a lawyer. So if you guys want to grab a beer later, come find me. I will still not be your attorney at that point in time. I'm struggling today. There we go. What's on tap? All right, so we're going to go through the entire process of setting up your attorney-client, just kidding, of setting up your independent security consultant and client relationship. And we're going to start at the beginning. What's included in the contract? How do you get the documents that make up the contract? What pieces do you really care about? What do you need to know about the statement of work and the scope of services? What are the sticking points in the contract? And then we'll have odds and ends, a recap, and resources. All right, so what documents do I need? Your standard set of documents for an assignment should include an NDA, which is, hey client, you don't talk about my shit and I won't talk about your shit. Your master services agreement, which is a high-level umbrella document that at a general kind of high-level area says, here's what this contract purpose is, here are some provisions like indemnification or liability, who, what, when, how, where, why. And then you have your scope of services and statement of work. And this is going to be an extremely detailed document or set of documents depending on what services you're providing. And this is where you talk about the project, the timeline, the phases, the exact compensation, who's working on it, when we're talking to who, every little nitty-gritty detail that you need to get in on a piece of paper with your client with a signature to make sure you get paid at the end and don't get sued. And last but not least, authorizations. And there's an asterisk here because it's your get out of jail free card if you're doing physical security. So you don't want to show up, break into client premises after they told you, and then have no way to escape being in prison if you're caught. And that's pretty industry specific for you guys. So if you have other folks that are practicing physical security stuff like that, then you should make sure you have all of the current industry best practice standard, all the buzzwords. Okay. How you should think of these documents. NDA is number one on this right-hand side. Because you guys are information security, it's probably going to be the very first thing that you sign with the client. And it's the one where you're going confidential information, proprietary information, you're defining terms, we'll get more into that later. After you have an NDA, you get to the MSA. And the Master Services Agreement, giant bubble, is going to be the thing that governs all of your statements of work, which are the SOWs. Frequently, if you're just working on one assignment or a long project, you're going to have one statement of work. But if you have a really great relationship with the client, you might end up with multiple statements of work. And if it involves a get out of jail free card, that's going to be something you describe in the SOW, not a standalone document. Okay, The non-disclosure agreement. I, consultant, won't share your information externally, and you, client, won't share my information. What you see on the bottom left-hand side, or bottom right-hand side of this, left, is the non-disclosure agreement with the date, the client address and information, and the recipient, which is you. These are all things that have to be put in there explicitly or expressly to make sure that you know that it's a legal document binding these two parties. So date, identify yourself and the client, the address, which is your business address, and then the purpose. What is it that you're doing with this NDA? Also in the NDA, what you're going to find is people will frequently define confidential information. What types of information are actually confidential? Is it stuff that you tell your client he has to mark confidential, or could it be any type of information that is considered business information? You have to be very careful in defining those terms. Similarly, proprietary information. Is all proprietary information also confidential? Probably, but you also want to lay that out. So a lot of what we're going to talk about as we continue is explain it like I'm 5, but in a contract. So you are telling your client in the stupidest, simplest terms what is covered and what isn't covered. And then you get to the master services agreement. Now, if you remember, this is the umbrella document. And we've got 3 parts of the master services agreement that are important, or 3 sort of ways to bucket concepts in your master services agreement. So the basics, just like the NDA, parties, purpose, definitions. What are you doing? And then during the agreement, what are your responsibilities and what are your client's rights and responsibilities? Can you assign the contract to someone else? So if you're an independent security consultant, do you have the right within your contract to say, hey, you know what? I actually have to go on an emergency vacation and need someone else to do this work for you, and I have the right of assignment, so client, I'm going to go ahead and assign this away. Representations and warranties, which are basically factual things. So your client's going to say, all of these things are facts, and I promise you they're facts so you can rely on them when you're doing work for me. And then payment. How are you getting paid? Is it in Bitcoin? Please don't do that. Is it US dollars? Hopefully. Whatever it is that you're doing in terms of payment, phasing, type of cash, when you're getting it, you can put that here as well. End of agreement, very critical, is the limitation of liability. How are you getting sued? Hopefully you're not, but how much can you get sued for? And what can you get sued for? Indemnification, which is protection from being sued for things where your client should be standing in your shoes. Severability, if a court just throws out parts of the agreement, then can you separate certain parts of the agreement from others so that you make sure that you're still getting paid or still able to complete other contract work? The governing law, so if you're both entities based out of California, is your governing law New York? Is that helpful to you? A waiver, which is basically saying if you breach a contract, do you waive the rest of your rights? Or if you breach a certain part of your contract, do you waive the rest of the things that you can do? And then IP. And I'm barely going to touch on IP, but when you get to the resources section, there will be some verbiage for you to look at. Okay, the statement of work. Protecting yourself. This is the most critical thing, and we'll get into it again later. But here are the pieces of the statement of work that matter, because again, you're going to be talking about who, what, where, when, why, and how in extreme nitty-gritty detail, and I really can't emphasize that more than I am right now, like extreme. So why are you doing this? What exactly is the purpose? Are you doing some type of like network security assessment? What is the project schedule? Are you having an initial call and then a second call and then another meeting to make sure the scope is correct and then getting started? What are the exact targets? Are you working for just the big company, or are you also working for smaller vendors that rely on this big company? Well, the shit you're doing upstream flow downstream, and does the downstream person know? Methods. A lot of times you're going to get into an assignment and you won't really know what the methods are going to be yet, perhaps, like specific tools. But you should have a general idea of what you're doing. Then you have controls, everyone's least favorite because it's probably a compliance checklist. But your client might need you to do that. So you need to say, here are the compliance things that I'm going to check for you, and here's the type of report I'm going to provide, which is where we get to deliverables, the total cost, And finally, a provision that the SOW is subject to the MSA. And we'll talk more about that later. Also, am I talking too fast for you guys? We're good. Okay, and then the last one is the authorizations, which we touched on earlier, so I'm going to slide right past it. But it's that get out of jail free card. Please keep in touch with your peers who also do this. All right, how do you get these documents? So you're just like, man, I want to be a security consultant. Or, dude, I'm a security consultant, but all I have is this fucking contract. What do I do with it? Ideally, you're going to want to start with phase one, which is client reaches out to you, or you reach out to client. And at this point, they might send you an NDA, or you might send them an NDA that you've drafted. And you guys say, okay, we're going to have preliminary conversation based on what we understand about each other. And we're going to have this initial meeting where we start scoping out what the client needs. Now, clients have a really hard time telling you what they want. So the client typically cannot enumerate or express to you exactly what they want you to do. So you have to dig. This is where you're playing detective, like old school Nancy Drew, whatever that was. You have to ask them exactly what, exactly why, and what their end goal is. And a lot of times you want to start that conversation off and say, what is it you need this to do for you? And what do you need at the end of this? And then you'll slowly be able to drill down into a conversation that results in a scope of services and a proposal, and hopefully also your version of a master services agreement. Or theirs. Sometimes it's easier to work with client on theirs, but you still have to be very careful about some provisions, which we'll talk about later. Then you start the negotiations for your master services agreement. So you've got definitions, how you're getting paid, indemnification liability, and how a contract is terminated. Like, can your client just decide that he's going to walk away because he doesn't like the things that you've provided, that you've provided to her? You want to make sure that there are absolute notice rules for termination so that one party can't just walk away without paying you. Which, by the way, might sound weird, but I've seen a lot of that. I've seen a lot of people end up just not getting paid or paid much less than what they're owed. Next is your SOW negotiations. And this is where you make sure you clarify the targets, both parties' responsibilities, what happens in terms of if there's a delay, and then deliverables. For example, is it your client's responsibility to make sure that you're able to access the premises to do the things you need to do? And are you on the hook if they don't make that access happen and you're behind project schedule? All right, what provisions do you really care about? You can probably figure this out by now, but there's 5. So the big 5, done right, will protect you from trouble. The first one is a document. It's a statement of work / the scope of services. And then 2 through 5 are provisions of interest. So they're provisions that you're going to find typically within your MSA. The limitation of liability, the confidentiality, indemnification, and contract termination. Now, when I say confidentiality requirements here, I also am referring to the NDA, because you don't want to get stuck in an NDA or a confidentiality requirement that's never ending. So you don't want to be eternally bound to secrecy for a client. And a lot of times clients, unsophisticated or sophisticated, will ask you to sign an NDA that never ends. Okay. All right, what do you need to know about the statement of work and scope of services? So we still need the process, the purpose, process, scope, and deliverables. And if you're not careful about crafting these with your client, you're going to end up with situations where, let's say you're working with a client and you find a vulnerability that they didn't ask you to actually look for. There's nothing in your contract that talks about what you do in that situation. And so your client can say, you know what, guy, you went out of the scope of your contract. There's nothing in this contract that says what you're supposed to do with that. And then you called me and told me about this. I think you're a hacker. I'm going to sue you. Not a position you want to be in, because you're curious and smart and you know your shit. So what you want to do in this scope of work or statement of work is say, hey, if I happen to find something interesting, This is how I'm gonna tell you. We've discussed this. You can't sue me for this later because I advised you about it. And I told you what the risks were, and that's it. That's all you need to know, and we've agreed on that. So those are the type of things that you want to cover. All right, then we get to our odds and ends. How do you get paid? One of the most important things I see is that people get to the statement of services and have their MSA and have a great looking contract, and then it's like after 6 months of work, you only get paid at the very end of the 6 months when your client likes the deliverable. Well, shit. What if the client doesn't like the deliverable? Did you actually put any provisions in about what is acceptable to the client? Can they ask you to cure it? Can they say, I'm gonna give you 2 weeks and you give me a better deliverable, and you do that until like the end of time and the board is done and they're out of money? This is a big one, especially if you work with startups or small companies or small mid-sized companies. You wanna make sure that you phase out the payments. So you wanna say phase 1 was month 1 and 2, phase 2 is month 3 and 4, phase 3 was whatever, and say at the end of each of these phases, I'm gonna give you X, or I've done X and you pay me Y, and I'm gonna invoice you regularly. And that way, at least you make sure you're consistently getting paid, not waiting for one bulk check at the end of the day, 6 months later, that might never come. Also, IP. Whatever you bring in is yours, and whatever they bring in is theirs, and they don't get to take your stuff. That's basically what the contract needs to say at the end of the day. But if you need to talk to an intellectual property lawyer, if you're bringing a lot more than just your skills and tools, you should probably talk to a lawyer to make sure that you have the licensing and the copyright written correctly inside of your contract. And there will probably be boilerplate language that you can pull, and I have some resources at the end of the slide deck that you can check out and see if it covers that. Track changes. This is something that Wendy Knox Everett and I were talking about, because if you're on Microsoft Word and you track changes, you have to make sure that you turn off the history of track changes. Otherwise, after you send it, I get an email, a Word document, and it gives me all of the comments people made to each other about particular provisions that are like, we don't really need to argue about that one. And I'm like, great, we're gonna push really hard on this contract provision and make them agree to a certain liability cap that they originally sounded like they weren't going to. So make sure you get rid of that feature before you send over redlined Word documents, which you will be doing if you're working on a contract. So will you get sued? Third parties, well, actually, let's answer that question. Will you get sued, guys? How many of you say yes or no?
Yes.
Yes, you're probably gonna get sued. Now, lots of lawyers like to be bullies and trolls. I've already heard about that once this week, so you should make sure you bully them back, but please don't troll. Third parties are a point of interest for being sued, as is your client based on your contract, and then the CFAA. Now, third parties who are affected by the things you do for your client can sue you based on nothing that exists in the contract, which is why you need to make sure that your scope of services, indemnification, and limitation of liability with your client cover you if your client's asked you to do something that's going to potentially screw over a downstream vendor, or downstream company, or someone who relies on your client. So make sure you limit that first third-party bullet point so that you're not leaving yourself open and exposed. Your client, your contract, back to limitation of liability and indemnification. You can tell the client that, hey, you can sue me for like wrongful deeds or extreme negligence, but only for $300,000. And that way, if you do get sued, you're looking at a limited amount of money that's potentially out of your hands. And you've said you can only sue me on these two things. That's the whole point of limitation of liability, and you want to make sure, again, you're limiting your exposure. Last but not least is the CFAA. You're open to civil and criminal liability under the CFAA, or civil action and criminal action. So on the civil side, which is like your client basically, they can say you had unauthorized access or exceeded authorized access. How do you protect yourself from getting that type of an accusation? By making sure that you've really scoped out in your contracts what you're able to touch, what you're going to touch, why you're touching it. Because that way you'll have the grounds, you've laid the groundwork to say, you know what, this was all authorized work. It was not unauthorized, I didn't exceed that access. This is also where a lawyer will be really helpful if you do end up in litigation, because there are things like circuit splits and stuff, and it gets really complicated really quickly. If you're being prosecuted under the CFAA, you've done something else, stop fucking up, and probably call the EFF. So, all right, recap. That was a lot. What are the takeaways? Carefully define your scope of services and your statement of work. Don't leave liability, indemnification, how you get paid, or termination provisions ambiguous. Draft your own NDA and MSA so you have a form. Ask your peers for their suggestions and resources and share the knowledge. This one's really important, I think, across industries. If you've got someone who's doing sophisticated work for a client, build your own library and start merging documents and make sure they make sense. And that way you'll have something that's up to date, recent, tested, and tried, and you won't be just struggling to make shit up on your own. All right, many thanks to you guys. BSides is awesome, and especially Clint for being my awesome mentor. And these are the folks who helped me with the slide deck for y'all and gave a lot of feedback, so I really appreciate them. Here's the link to get the slide deck on SlideShare. You can download it. There are provisions later. There's sample documents and provisions. I obviously didn't fill in the XXs. And a simple 2 slides of chart, like what are legal terms and what do they mean? And then examples of different provisions where I've said where you can put in your company name and your client company name. So we go through SOWs, assignment, choice of law, compensation, indemnification, limitation of liability, termination, project phases, rights, IP rights, and who the hell do you hire if you're having problem with legal stuff? Because that can be hard to figure out. All right, any questions?
Can you go back to the slide with the slide share on it?
Yes.
None of us got that 50-character URL. 5 seconds ago.
I know. Sure, go for it.
Wait.
So in addition to the SOW, do you recommend a rules of engagement form as well?
I actually think that's a great idea. I would add it as an exhibit, and then make sure that your MSA and SOW refer to that exhibit. So all of the terms within are also inclusive of and subject to this exhibit.
Okay.
Yeah.
Sorry.
Sure. Over here.
Over here. Okay.
You said not to sign an indefinite NDA. Why? And why would someone try and make that a thing?
So I actually just call it lazy drafting, which if any other lawyers are hearing this are going to get really mad at me. But it's just lazy. Like, they just want the rights to keep the secrets forever. Unless it's extremely sensitive, I wouldn't sign an eternal NDA. You have a right to brag about the work that you've done after a certain point in time where it's no longer super sensitive and confidential. And as people who are building your brand, you should make it a point to make sure you have the ability to do that. So 2 years after an engagement, you should be able to say, hey man, I worked for this crazy awesome company or crazy shitty company, but here are the cool things I learned and now I know how to do XYZ for you. So.
Is it even possible to write your liabilities section in such a way that you are not going to be sued upstream?
No, you will still be sued, but it's a way to make it defensible. So if you have that piece of paper with certain things that you can't be sued for, you'll be able to write off most of the things that you'll potentially be sued for and cap the amount you can be fined. But lawsuits are always possible, and that's why making sure these are as close to airtight as you can get is important.
So you said to attach the rules of engagement as an exhibit to an SOW. How do you do that practically?
It would just be so.
Do you sign it at the same time as the SOW, or can you sign it later?
Yes, sign it at the same time unless you're working with a client that's friendly, in which case you can say, hey, let's incorporate this at a later date. So let's say I have an SOW that I've already signed, and then I've talked to my client some more, and my client's like, this is actually what I need, and I need to go back and kind of amend that SOW. Yeah. Well, then you can say, instead of amending the SOW, I'm just going to attach the second page. Please put it all into one PDF, have it signed, and we'll execute it again. You can have the date and read it back. Yep.
Last question.
Do you recommend that independent contractors generate these documents themselves or go to a lawyer and have them cover all this crap for you?
If you have access to a nonprofit organization or a cheaper lawyer who can help you with this, I highly recommend you do that because it gets complicated quickly. So having a lawyer to do it from the front end is great. And just to let you know, I'm not looking for clients. I work for a company, so this isn't my pitch to try to get business. But if you can get a lawyer to build it, please have a lawyer do it. And if you can't, use this slide deck and the resources that I've provided and things that your friends give to you. And then when you read it, here's the rule. Don't be a dick, and people won't be a dick to you. Cool. All right, thank you, everybody.